You're on the record in 2024 TR 617, State of Kansas versus Abel Estrada. Paul E. Dean for the state and Mr. Estrada appearing in person and pro se. The defendant was found guilty February 14th, 2025, ordered to pay scheduled fine in 108 within 15 days. And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record, and they send it in. And the next thing is we're just waiting for the plea.
All right. First of all, I'm not making if Mr. McClendon has not withdrawn, I'm having him do so now because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one because throughout the trial, you kept insisting that you, if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even an offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, maybe I was going to double check the journal entry. I was thinking Mr. McClendon, maybe even on the last journal entry, had been allowed to withdraw, but there was delay in me getting the paper, those journal entries to the county attorney's office, because I had a few to complete after that day. So they had not all been emailed in. So I think they might still be in the process of being e-filed, because then the following week as I recall correct, I didn't travel to Greenwood County because of all the snow. Okay. I did my meeting with the commission via Zoom. So, but today the court's ordering that Mr. McClendon is withdrawn.
Yes, because
we're jumping straight into the courtroom in Kansas, where Abel Estrada is facing some very unusual charges. He's already been found guilty, and now the big question: can he even manage to file a proper appeal? What makes this case fascinating is not just the legal procedure, but the personality at play. A defendant navigating the system entirely on his own, while the judge keeps a watchful eye. Stick around, because we're going to see fines, bonds, and the reality check that comes when the courtroom doesn't bend to your beliefs. Buckle up. This is going to be intense.
Have you seen anything about a waiver on his appeal bond?
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by, even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to. But I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have it all paid.
I actually started the process, and I send the appeal notice, and I actually send I requested what's it called? The report. No, the journal entry from Mr. Dean office, but I haven't got it because the journal entry reflects $50, but I never got it. I never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel. However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Estrada was also wanting them to violate their oath as an attorney and make arguments
That is incorrect.
Don't interrupt, please.
and make
Right here, you can see the tension rising. Estrada insists he submitted a notice to appeal, but the judge isn't letting him off the hook. This isn't just paperwork. It's the backbone of the legal system. The judge is firm. It's not enough to say you want to appeal. You have to actually do it. And notice how the standby attorney, Mr. McClendon, has to step back. This is a classic example of what happens when a defendant refuses traditional legal advice. It's already clear. Navigating this case alone is going to be a monumental challenge.
And it looks like from my docket notes, he was just ordered to pay 108 court costs. It says scheduled fine, but isn't this a misdemeanor?
I just asked for the basic fine. What I refer to as basic fine, it's not really a scheduled fine, but it was $50 because he did actually have it. He just refused to
Put on his car.
display it.
That's right. He refused to put it on his car, put on that cardboard.
So
Made
despite
up.
all the rigmaroles, I treated it just as any other case.
Okay. All right, Mr. Estrada, we're going to make you come back for another pay or appear in 30 days. Missy, when is that?
March 28th at 11 o'clock.
All right, March 28th, 11 o'clock. We're going to review this and see if you've paid your case and moved on, or if you're going to keep fighting it. And you understand. Never mind. All right, but I understand, Mr. Estrada. What is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the
Oh.
verdict.
Okay. And you want to maintain your argument that that cardboard tag was legal. The tag that you made was legal.
Yes.
This is one of those moments that really shows the contradictions at play. Estrada claims he's trying to get a waiver for the appeal bond, but the judge is skeptical. You can almost hear the disbelief. If you can't pay $158, how are you going to hire an attorney? The courtroom becomes a microcosm of real-world consequences, claims versus reality. And the humor here is subtle but sharp. The judge's tone says it all. Sometimes enthusiasm and conviction just aren't enough to override legal facts. Watch how this tension unfolds. It's a textbook lesson in courtroom pragmatism.
Jesse Travis McLaughlin.
Yeah.
It's the state of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in the
man must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory
So
authority,
what
and I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
All
Not a
right,
sovereign citizen.
you sound like one.
Well, I'm not.
All right, I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Here's the real jaw dropper. Not one, but two attorneys refused to argue a case because it would violate their oath. That's right. Estrada walks in thinking he knows the Constitution better than professionals, only to be met with a hard reality check. The courtroom isn't a debate club. It's a structured system where ethical boundaries matter. And this moment perfectly illustrates the clash between personal belief and professional responsibility. The judge allows a standby attorney, but it's clear sometimes the system simply won't bend to personal theories, no matter how passionate the defendant is.
Who is the individual? And sir, what is your name at the jail?
I'm Roman Campbell. I mean, I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you 1 second. I need to look over some things. Are you representing yourself?
No, sir, I'm not representing myself. I'm presenting myself.
Okay. I mean, do you have a court-appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Okay, calling case Tom King 25 William Boyd 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person for life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk because I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need another man to present.
So are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81. It carries a maximum penalty of 93 days in jail, possible fines of $500 and/or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm entering a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
Yeah. I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. It's not. Just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Personally appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the.
As we wrap up the Kansas segment, pay attention to the stakes. Estrada must either pay his fines, post the appeal bond, or appear again. It's a ticking clock scenario, a real pressure cooker. The judge is firm but fair, giving him time but making it very clear. The system moves forward with or without your participation. This is a reminder for viewers. Knowing your legal responsibilities isn't optional. And for all the self-represented defendants watching, this is a cautionary tale. Passion alone does not equal victory. Now we shift gears from Kansas to Michigan, and things are about to get even more chaotic. Meet Jesse Travis McLaughlin, a self-proclaimed sovereign citizen, ready to challenge the court before he even begins. These cases are a mix of spectacle and legal reality, where courtroom procedure meets personal ideology head-on. The judge doesn't waste time and immediately shuts down the nonsense. This is where the drama is amplified, authority versus belief, and the tension is practically tangible. Keep your eyes on the body language. It tells as much of the story as the words themselves.
To Maxim at North America, North Gate, Turtle Island. I come under protection by way of Treaty of Peace and Friendship, 1836, between United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kemp Hill in all capital letters, ins legis, the corporate entity. So that be noted for the record, please, sir. I also reside in domicile at. That's my address. That's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there, and so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, that date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely. He must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like one more thing, sir. I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone to be that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned. Also, so
okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.
Right here, the exchanges get intense. McLaughlin challenges the judge's jurisdiction, citing point of order and sovereign citizen logic. But the judge doesn't play games. Statutory authority, clear legal procedure, and professional detachment come into play. This is a masterclass in courtroom control. No matter how convoluted or dramatic a defendant tries to be, the law prevails. For viewers, it's both educational and fascinating to watch someone attempt to bend reality to their will, only to be met with an unwavering system that enforces rules and upholds standards.
On how much they can take out of your checks. The reason that you keep getting hauled in is because you're not paying the full amount of child support.
But at the time that they was taking the money out of my checks, they issued the warrants.
Right. If you owe $100 and they only collect $70, you're gaining $30 a month in arrears. And once the arrears hit a month, well, that's why I was asking, because The amount of child
Both.
support that are these weekly checks or monthly?
Weekly, sir. It's
Okay.
440. It was receiving that, and at the time,
And how much did they say that you owe?
just now recently,
Yeah.
they said I was in arrears 5,000.
Okay. Yeah, because I have a feeling that's what's happening. Now
But-
you have the right to have this child support reviewed at this point in time. It's been 3 years since the last order, so it can be reviewed for you.
But my whole thing is, I wasn't paying because last year, April,
Mhm.
they got a $5,000 check on my behalf
From whom?
from an employer, from a settlement, which was from an employer.
Okay, and they confiscated all 5,000?
Yep, it was.
Okay, and that should have gone against any arrears. Now their next question would be, are you sure they got it?
Child support?
No, the $5,000 check.
Child support got that $5,000 check.
Are you sure they got it?
Yes, I'm sure they got it.
Because what I would do if I were you is ask for an accounting of the case to make sure they got it. An accounting will give you a computer readout of every month that you owe and every payment that's been made. And they do it in writing. So if you write them and ask for an accounting of your child support, because some of this stuff will not be in the court file. The court file is a public file. So the court does not know how much your arrearage is unless they apply for a show cause. Okay.
Okay. And I haven't been paying recently because I was under the impression that the obligation is $445 a month.
Well, it looks like how have you not been are you not employed anymore?
I'm at work right now.
Okay. Well, it's because the employer automatically takes it out.
Right. I just started this job, and
Okay. Then you have to notify the front of the court what job you changed to, so that they can apply it to the appropriate. Because they issue an automatic income withholding order. Again, that does not go in the court file because it contains some very specific information.
And there you have it. 2 different states, 2 very different defendants, but the same lesson. Courts operate on law, procedure, and ethical responsibility, not personal belief. Abel Estrada faces fines and appeal requirements, while McLaughlin discovers that sovereign citizen arguments won't hold up against a sharp judge. These cases are more than entertainment. They're reminders of how crucial it is to understand legal obligations. If you found these courtroom showdowns as shocking as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns of real court drama.